Welcome to Studious. In this lecture, we tackle one of the most densely legislative topics in forensic medicine, the high-yield forensic acts and the legal codex every clinician must command. India's legal framework governing medical practice has undergone a seismic transformation. The old Indian Penal Code and the Code of Criminal Procedure have been replaced by entirely new legislation. The Bharatiya Nyaya Sanhita, known as the BNS, and the Bharatiya Suraksha Sanhita, known as the BNSS. Alongside these, 4 additional landmark statutes directly shape how doctors practice, document, consent, and are held accountable. The Consumer Protection Act, the Mental Health Care Act, and the Transplantation of Human Organs and Tissues Act, commonly known as THOTA. If you are preparing for MBBS finals, NEET PG, FMGE, or clinical practice in India, every section number, every threshold, and every legal distinction in this video is directly exam relevant and clinically actionable. We will move systematically from criminal responsibility and consent through offenses against women, bodily harm, homicide, and consumer rights, all the way to mental health law and organ transplantation. This is your complete statutory map. Let us begin.
For over 160 years, Indian criminal law was governed by the Indian Penal Code of 1860 and the Code of Criminal Procedure. These frameworks, inherited from British colonial legislation, were considered fragmented and inconsistent, with medico-legally relevant sections scattered across unrelated chapters. In 2023, a historic legislative overhaul came into force. The Indian Penal Code was replaced by the Bharatiya Nyaya Sanhita, the BNS, and the Code of Criminal Procedure was replaced by the Bharatiya Suraksha Sanhita, the BNSS. The renumbering is extensive and must be memorized. Murder, previously IPC Section 302, is now BNS Section 101. Dowry death, previously IPC Section 304-B, is now BNS Section 80. Harassment by a husband or relative, previously IPC Section 498A, is now BNS Section 85. False evidence, previously IPC Section 191, is now BNS Section 229. In procedural law, the police inquest under CRPC Section 174 is now BNSS Section 194. The magistrate inquest under CRPC Section 176 is now BNSS Section 196. Critically, all offenses against women, from dowry death to harassment, are now consolidated under sequential BNS Sections 80 through 86, rather than scattered across homicide and assault chapters. This unified codification is a direct policy outcome, making both investigation and prosecution more coherent. BNSS also introduces increased penalties for perjury, directly relevant to any physician testifying under oath.
Not every person who commits a harmful act bears full criminal responsibility. The law recognizes that age and mental state are fundamental determinants of culpability, and these principles are codified in BNS Sections 20 through 24. BNS Section 20 deals with children under 7 years of age. The law provides absolute immunity. A child below 7 is conclusively presumed incapable of forming criminal intent, and no criminal prosecution can proceed regardless of the act committed. BNS Section 21 governs children between 7 and 12 years of age. Here, the rule is conditional responsibility. The child can be held culpable, but only if it can be demonstrated that they possessed sufficient maturity to understand the nature of their act or appreciate that it was wrong. This is a critical distinction. The prosecution must affirmatively prove cognitive maturity. BNS Section 22 addresses mental insanity, applying the landmark McNaughton rule. A person is not criminally responsible if, at the time of the act, they suffered from such a disease of the mind that they were unable to understand the nature of their act or appreciate that it was wrong. Section 22 is the statutory codification of this defense in Indian law. Finally, BNS Sections 23 and 24 address intoxication with a bifurcated outcome. Involuntary intoxication, where a person was drugged without their knowledge, negates criminal responsibility entirely. Voluntary intoxication, on the other hand, provides no legal defense whatsoever. The person is fully criminally responsible.
Two BNS sections define the boundaries of lawful medical intervention, and every practicing physician must know them precisely. BNS Section 27 governs consent in standard care, specifically covering minors and the mentally ill. For these patient groups, no procedure may be performed without valid consent obtained from a legally authorized guardian prior to any clinical intervention. This is not a formality. It is a legal prerequisite whose absence exposes the physician to liability for assault under the BNS, regardless of the clinical outcome or beneficial intent. BNS Section 30 is the life-saving emergency exception. In genuine life-threatening emergencies, a physician may and must proceed without consent when the patient is unconscious, incompetent, or otherwise unable to consent, and no guardian is immediately available. Critically, the law makes clear that waiting for relatives to arrive when an unconscious trauma patient presents to the emergency department is not merely suboptimal, it constitutes malpractice. The emergency creates an implied legal duty to act. There is a critical warning embedded in these provisions that every student must internalize. Treating a non-emergency, fully conscious, competent patient without obtaining valid consent is legally equivalent to committing torture under BNS provisions. The law draws no distinction between a harmful touch and an unconsented beneficial medical touch. Both are violations of bodily autonomy. Document your consent, every time without exception.
The BNS consolidates sexual offenses against women under Chapter 5, titled Offenses Affecting the Human Body, in a structured, escalating severity framework that every forensic medicine student must map precisely. BNS Sections 63 and 64 establish the foundational definition and general punishment framework. Section 63 provides the legal definition, penetrative sexual assault without consent, and Section 64 prescribes the general punishment framework, which includes a minimum of 10 years rigorous imprisonment, extendable to life imprisonment. BNS Sections 67, 68, and 69 address circumstantial offenses, situations where the surrounding circumstances aggravate culpability. These include sexual assault during marital separation and assault by persons in positions of authority or custody over the victim, such as police officers, jailers, armed forces personnel, or those managing healthcare institutions. BNS Sections 70 and 71 cover the most aggravated categories. Section 70 addresses gang rape, defined as rape perpetrated by two or more persons, which carries a mandatory 20-year imprisonment or life sentence. Section 71 governs repeat offenders, prescribing enhanced punishments for previously convicted perpetrators. BNS Section 66 sits at the apex. It governs the gravest outcome, rape causing the victim's death or resulting in a persistent vegetative state. The punishment is death or rigorous imprisonment for the remainder of the offender's natural life. BNS Section 72 provides strict penalization for the public disclosure of a rape victim's identity, such as through media publication, protecting victim privacy and dignity.
Beyond sexual offenses, the BNS provides a comprehensive catalog of crimes against women, encompassing harassment, indignity, and marital cruelty, all clustered in the sequential sections 74 through 85, reflecting the BNS's unified approach to protecting women. In the harassment cluster, sections 74 through 79, the law addresses a spectrum of offenses. Section 74 covers indecent assault, any non-penetrative assault with sexual intent. Section 75 covers sexual harassment in the workplace and public spaces, a direct statutory reflection of the Vishaka guidelines. Section 76 addresses criminal disrobing, the forcible removal of clothing with intent to humiliate. Section 77 targets voyeurism, commonly known as the peeping Tom offense, capturing or watching a woman in a private act without her consent. Section 78 criminalizes stalking, any persistent, non-consensual following, monitoring, or contacting of a woman that induces fear or distress. Section 79 covers insulting the modesty of a woman, any act, gesture, or word designed to outrage a woman's modesty in public. The marriage and cruelty cluster, sections 80 through 85, begins with Section 80, dowry death, a critical section for forensic practitioners. Section 81 covers deceitful cohabitation, inducing a woman to live with someone under the false belief of lawful marriage. Sections 82 and 83 address bigamy and fraudulent marriage. Section 84 criminalizes kidnapping a married woman. Section 85 prescribes punishment for subjecting a wife to cruelty by a husband or his relatives, the statutory equivalent of the former IPC Section 498A.
The legal framework governing pregnancy termination in Indian law is nuanced, outcome-dependent, and critically tested in forensic medicine examinations. The BNS codifies a spectrum of offenses based on the consent status, intent, and outcome of the termination event. BNS Section 88 governs legal abortion, a termination performed with the woman's valid, free, and informed consent, and in compliance with the Medical Termination of Pregnancy Act, which permits termination up to 20 weeks under a registered medical practitioner, and up to 24 weeks in specific circumstances such as rape, fetal anomalies, or contraceptive failure. When performed within these legal parameters, Section 88 applies and the physician is fully protected. BNS Section 89 addresses abortion without consent, a criminal act regardless of the clinical method or outcome. This applies whether the procedure is performed coercively, deceptively, or under duress. BNS Section 90 governs outcome-based liability. If the miscarriage or termination results in the death of the mother due to negligent technique, untrained personnel, or unsafe conditions, enhanced criminal liability applies. BNS Section 91 targets intentional feticide, a deliberate act specifically taken to prevent a living child from being born alive. This may overlap with sex-selective abortion practices. BNS Section 92 represents the apex of fetal harm, causing the death of a quick unborn child, a fetus that has begun to move in utero, typically after the 20th week, through an act amounting to culpable homicide. This carries the most severe penalties and may overlap with homicide law.
The forensic assessment of bodily injury is not merely clinical. It has direct statutory consequences that determine the severity of charges, the applicable BNS section, and ultimately the quantum of punishment. The BNS provides a structured 4-section matrix for classifying bodily harm, which must be committed to memory. BNS Section 114 provides the standard legal definition of hurt: any bodily pain, disease, or infirmity caused to a person. This is the baseline category for physical injury. BNS Section 115 governs voluntarily causing hurt, an act of intentional hurt inflicted willingly. When a person deliberately causes hurt to another, Section 115 applies. BNS Section 116 provides the definition of grievous hurt, a legally elevated category of injury. The 8 specific forms of grievous hurt include emasculation, permanent privation of sight in either eye, privation of hearing in either ear, privation or destruction of any member or joint, destruction of any joint's power, permanent disfiguration of the head or face, fracture or dislocation of a bone or tooth, and any hurt that endangers life or causes the sufferer to be incapacitated for 20 days or more. BNS Section 117 covers voluntarily causing grievous hurt. The situational modifiers are equally important. Section 118 applies when dangerous weapons, guns, knives, are used. Sections 119 and 120 address hurt caused to extort property or force a confession. Section 121, critically relevant to physicians, imposes severe penalties for deliberately hurting a doctor or public servant to deter them from performing their duty. Section 123 covers administration of poison. Section 124 specifically addresses acid attacks, vitriolage, and Section 125 covers any act endangering life or personal safety.
The legal classification of lethal acts forms the pyramid of lethality in BNS law, and understanding the gradations between negligence, culpable homicide, murder, and abetment of suicide is essential for forensic medicine practice, both clinically and in court testimony. At the base of the pyramid sits BNS Section 106, medical negligence resulting in death. This is the section that directly governs physicians. When a patient dies due to a registered medical practitioner's negligent act, Section 106 applies, prescribing up to 2 years imprisonment. This is a cognizable, non-bailable offense, making it one of the most consequential sections in clinical practice. The middle tier of the pyramid comprises culpable homicide under BNS Section 102 and culpable homicide not amounting to murder under Section 105. Culpable homicide is the broader category, causing death by a wrongful act with the knowledge that death is likely. Murder, defined under Section 103, requires the specific intent to cause death or grievous harm that the perpetrator knows to be imminently fatal. At the apex, BNS Section 103 for murder, Section 104 for murder committed by a life convict, and Section 109 for attempt to murder. Flanking the pyramid are two suicide-related sections. BNS Section 107 governs the abetment of suicide for a child or insane person, recognizing that these individuals lack autonomous agency. BNS Section 108 addresses abetment of suicide for a standard adult, a critically important section in the context of bullying, coercion, and dowry-related harassment leading to self-harm.
The Consumer Protection Act, abbreviated as COPRA, represents one of the most transformative legal developments in medical practice in India. Its inclusion of medical services within the definition of consumer services was established by the landmark Supreme Court judgment in Indian Medical Association versus VP Shanta in 1995, and has since been reinforced by the Consumer Protection Act of 2019. The key question COPRA asks is simple. Was this a paid service? The applicability filter works as follows. If a patient receives services at a government hospital free of charge, COPRA does not apply. Nominal token fees or registration charges do not convert a free service into a paid service for the purposes of COPRA. However, if a patient receives fully paid services at a private hospital, a paid diagnostic center, or a private practice, that patient becomes a consumer under COPRA, and the physician or institution becomes a service provider. This shift in legal framing is enormous. The patient-consumer now holds 4 statutory rights: the right to safety, meaning protection from unsafe medical practices; the right to information, meaning full disclosure about treatment, risks, and costs; the right to choice, meaning freedom to seek a second opinion or choose between providers; and the right to redressal and fair trade practices, meaning the right to seek compensation for deficient services through the consumer forum hierarchy without the cost and complexity of a civil suit. This framework operates parallel to and independently of criminal proceedings under the BNS.
Once a patient decides to file a consumer complaint against a physician or healthcare institution, they must file in the correct forum, and the correct forum is determined entirely by the monetary value of the claim damages. This is the jurisdiction escalator of COPRA, and its thresholds were significantly revised by the Consumer Protection Act of 2019. At the base of the escalator is the District Consumer Forum. This forum has jurisdiction over claims valued up to 1 crore rupees. It is the most accessible tier. Claims can be filed at the local district level, making it the forum of choice for the vast majority of medical negligence complaints. The middle tier is the State Consumer Forum, which handles claims valued at more than 1 crore rupees and up to 10 crore rupees. Appeals from the District Forum also lie to the State Forum if either party is dissatisfied with the District Forum's decision. At the apex sits the National Consumer Forum, which handles claims exceeding 10 crore rupees and serves as the appellate body for State Forum decisions. 3 critical operational constraints apply across all tiers. First, the statute of limitations. Any consumer complaint must be filed within exactly 2 years of the date of the incident. Missing this deadline permanently bars the claim. Second, financial recourse. When a valid claim succeeds, the respondent is liable not only for the damages, but also for reimbursing the complainant's legal expenses. Third, deterrence against frivolous litigation. If a complaint is found to be deliberately frivolous or malicious, the forum can impose counterfines directly on the complainant, protecting physicians from vexatious harassment.
The Mental Health Care Act of 2017, commonly abbreviated as the MHCA, represents a profound philosophical and legal shift in how India treats persons with mental illness. Grounded in India's obligations under the United Nations Convention on the Rights of Persons with Disabilities, The act replaces the outdated Mental Health Act of 1987 with a rights-based, dignity-centered framework. The MHCA rests on 4 foundational pillars. The first is decriminalization. Under the old legal framework, an attempt to commit suicide was a criminal offense under IPC Section 309. The MHCA eliminates this entirely, recognizing that suicide attempts driven by mental illness are medical crises, not moral failures. Such individuals must be treated clinically, offered counseling and psychiatric support, not prosecuted and imprisoned. This decriminalization is one of the most humane reforms in Indian legislative history. The second pillar is absolute confidentiality. Persons with mental illness have a complete right to medical privacy. Their psychiatric history cannot be disclosed without explicit consent, even to family members. The third pillar is deinstitutionalization. A person cannot be admitted to a psychiatric facility solely on the basis of neighbor or family complaints. Hospitalization requires either documented medical necessity confirmed by a qualified psychiatrist or a direct court order. This prevents the weaponization of psychiatric institutions against vulnerable individuals. The fourth pillar is regulated electroconvulsive therapy. The MHCA strictly prohibits unmodified ECT. ECT must be performed under anesthesia with full medical precautions, eliminating the dangerous practice of administering shock therapy without muscle relaxants or sedation.
One of the most forward-thinking provisions of the Mental Health Care Act of 2017 is the legal recognition of advanced directives, sometimes called a mental health will. This mechanism addresses a fundamental challenge in psychiatric care. Patients with serious mental illness often lose decision-making capacity during acute episodes or progressive deterioration. How should treatment proceed when a patient can no longer express their preferences? The advanced directive solves this by operating in 2 sequential phases. Phase 1 occurs during the lucid state, when the patient is mentally competent, fully oriented, and legally capable of making autonomous decisions. During this phase, the patient proactively writes a formal advanced directive, a comprehensive document specifying their treatment preferences, the interventions they consent to, those they refuse, and any conditions under which hospitalization may be authorized. Crucially, during this phase, the patient also appoints a nominated representative, a trusted individual who is legally empowered to make healthcare decisions on their behalf when they can no longer do so themselves. Phase 2 is activated during the disability state, when the patient's mental illness has progressed to the point that they lose decision-making capacity. At this point, the pre-written advance directive automatically activates, and the nominated representative steps into their role. Throughout both phases, the entire process is legally monitored by the Mental Health Review Board, an independent statutory body that approves specific treatment protocols and reviews the necessity and appropriateness of hospitalization. This framework preserves patient autonomy, even when the patient themselves is no longer able to exercise it.
The Transplantation of Human Organs and Tissues Act, THOTA, was originally enacted in 1994 and has since been amended to address the evolving landscape of organ donation, brain death certification, and the persistent threat of commercial organ trafficking. THOTA operates as a compliance board with 3 distinct categories: green, yellow, and red, each defining a fundamentally different legal status. Green light scenarios are fully legal and compliant. These include donations involving organs and tissues such as bone marrow, corneas, kidneys, and blood from living donors or cadavers. For cadaveric donation, brain death must be formally certified by a board of physicians that includes a neurologist, the treating physician, the hospital medical officer, and a government-nominated member. No single doctor can unilaterally declare brain death. Living donors must be voluntary near relatives, parents, siblings, children, spouse. The surgery must occur in a THOTA-registered hospital with full transparent reporting to the appropriate authorities. Yellow light scenarios require rigorous clearance before proceeding. These apply when the living donor is an unrelated person, not a near relative. In these cases, an authorization committee must conduct a thorough inquiry to verify the absence of coercion, financial motivation, or exploitation. Only with explicit committee approval may the transplant proceed. Red light scenarios are absolutely and unconditionally banned under THOTA. Any form of commercial trading in human organs, any financial payment or compensation to a donor or their family for an organ trafficking is a cognizable criminal offense.
We close this lecture with the synthesis that transforms individual statutory knowledge into a unified, actionable framework, the Doctor's Legal Liability Codex. Every clinical situation maps to one or more of the statutes we have covered, and understanding those intersections is what separates exam success from genuine legal literacy. In emergency and consent situations, 2 BNS sections govern everything. Section 30 authorizes you to proceed without consent to save a life in a genuine emergency, and Section 27 mandates guardian approval for minors and the mentally ill in all non-emergency settings. Violating either creates criminal exposure. In physician protection, BNS Section 121, which imposes severe penalties for assaulting or deterring a doctor on duty, is increasingly relevant given rising incidents of violence against healthcare workers in India. This section provides statutory protection that physicians and hospital administrations must actively assert. In clinical failure situations, 2 parallel liability tracks apply simultaneously. Under the BNS, Section 106 governs criminal medical negligence, applicable when negligence causes death. Under COPRA, financial liability applies in civil proceedings, but only when the patient paid for the service. Free treatment at a government facility is COPRA exempt. For high-risk procedures, 2 additional statutes overlay. The Mental Health Care Act mandates that ECT must be performed under anesthesia, and THOTA mandates authorization committee approval for living unrelated organ donation. Mastering these intersections transforms legal liability from an abstract, paralyzing fear into a concrete, manageable clinical protocol. If this video has helped you, please like, comment, share, and subscribe to Studious for more high-yield content just like this.